Welcome to your favorite program, Law and Order. Law is everywhere, and if we are not aware about the current law, we'll be falling in trouble because not knowing the law is not an excuse. So we were discussing about one of the most important areas that each and everyone should know, which is land law, and we discussed some insightful ideas in our previous episode, and today we are going to focus about some common disputes regarding the law. So to do the honors, we invited Mr. Sapumal Bandara, attorney at law. Thank you very much, sir, for doing the honors.
Thank you, Thartha. Thank you very much.
Okay,
it's my pleasure.
Yes, when it comes to the land law, we had an insightful discussion in one of our previous episodes, and today, sir, let's focus on the common disputes related to the law. So as a practitioner, I have dealing with these land disputes for a long period of time, nearly 2-3 decades. What experience you do have regarding these common disputes?
Well, Saratha, to start off with, I must say that the majority of civil actions pending before our courts are land related. So there are many varieties of land disputes are pending before courts. So basically these land disputes are in relation to ownership, possession, right of way, and boundaries. So those are the common, the most common types of disputes. So now if you take for an example, now I think during our last program we were discussing about the acquisition of ownership.
Yes.
So there are disputes with regard to ownership. There can be one or more claimants to a land parcel. So those are the most common types of land disputes pending in our courts.
Right. Shall we start off with ownership?
Yes. Now ownership disputes are of many varieties. Now first is that, now I will give you a small example, that if I claim a property based on a purchase, that is, I say that I own this property by way of a deed of transfer, that I purchased it from the seller. And you might say that, okay, the seller is my father, but before he sells it to you, he had gifted it to me. So there is a conflict.
Yes.
There is a conflicting claims with regard to the ownership of the land. And in addition to that, now let's say I am the owner of the property, I am the paper title holder of the property. So I have a deed which has been executed in my favor. So I hold a valid notarially executed deed. You are in possession of the land.
Right.
And you may come up with the position that although you hold a deed in relation to this land, by way of prescription, I have become the owner. So my ownership is superior than yours.
Right.
So there is a conflict, there is a dispute. So there are disputes in relation to ownership in many ways.
Right.
So, and also there are disputes in relation to possession of the lands as well.
Right.
The possession is that the possession disputes are like, sometimes the possessors may have been illegally dispossessed. Now, Charita, even a person who is unlawfully possessing a land cannot be dispossessed illegally. So it has to be according to law.
Right. That means for a wrong committed, we can't employ a wrong methodology.
That's right. So even a person is occupying a land illegally, you have to resort to law,
right,
to dispossess him. So possessory or possession disputes arises when people are being dispossessed illegally. And there are another, we will go one by one in detail later. So there are another type of dispute relating to lands is with regard to boundaries. So demarcation of boundaries, when you have a common boundary demarcating your land and your neighbor's land. So there may be disputes over the boundaries. And also, although these are not so common in urban areas, in rural areas, there can be matters where right of way involve right of way, where you have not been given proper access to your property. So if somebody obstructs from accessing, so gaining access to your land, there will be another dispute relating to land. So there are number of or many variety of land disputes.
Right. So when it comes to ownership, can we discuss on the title itself, sir? Right. It conveys a good weight in this context.
Yes. Now, title is a concept where you can, as I described earlier, you can acquire title in many ways. So if it is by way of a deed of transfer or deed of gift, then you get a paper title. We call it paper title because you have a paper in your hand.
Yes.
And if you get title by way of inheritance, still you have title, but it's not confined to a paper. And also that if you have acquired title by way of prescription, you don't have a document or a notarial execute document in your hand, but still you have acquired your title. So the title is a concept which gives a right to claim the ownership.
Right. Okay. So in that sense, without the title, no ownership is there.
Yes. Now, title is a necessary component in ownership. You cannot claim ownership to a land without having title.
Right.
You have to establish your title. What is your right or what is your title to the land to claim your ownership? So it is something precedent to claim ownership. Now, in this regard, now I must say that now earlier the law was to register instruments, notarially executed documents in relation to lands at the land registry. So what is registered there in the land registry is the deed. So when the deed is registered in the land registry has no business to check the veracity or the genuineness of the deed. So anyone can execute a deed in his favor and then get it registered in the land registry.
Right.
But now after the introduction of the Registration of Title Act, now it is not the document you register but your title. So there is a difference between that. Now earlier under Registration of Documents Ordinance, what you register is your deed, not your title.
Right.
But now in terms of new law, that is in terms of Registration of Title Act, you register your title. But there are certain prerequisites. Now you cannot just go and register your title because there is a procedure. Now first the Survey General's Department has to prepare a survey plan in relation to a particular area, and it should be gazetted, and claimants must be given due notice to claim their land plots, and there should be an inquiry conducted by the Department of Title Registration to ascertain the veracity or the genuineness of the paper title they hold. And then after inquiry, if they are satisfied, if the Department of Title Registration are satisfied, they can issue two types of certificates. Right. That is first class ownership and the second class ownership. Now if you have so sound material to establish your title, you will be given a first class title certificate.
Right.
And you establish your title by way of some prescription or some other means not stronger than the notarially executed document, you will be given, because since you are in possession, you will be given a title certificate, but it is a second class title certificate.
So the validity differs with the first and second class?
No, validity is that the first class title, if you gain a first class title, you have absolute title to the land parcel. If you gain a second class title, it is always questionable before district court. There is a provision in the Title Registration Act itself. If you possess a second class title, it can be questioned in the district court, but not the first class title. There are matters which are referred to the district court pertaining to first class titles, but the validity of the first class title cannot be disputed in the district court.
Right. What is the scenario about this ejectment of this title when it comes to ownership?
Yes. Now, ejectment is where, now I will explain this to our viewers in some examples. Now, say that you are my tenant or you are my licensee. So, tenant, or you may be my tenant, you may be my lessee, or you may be my licensee.
Right.
There is a difference between that. Now, if you are a tenant, you pay me a monthly rent.
Right.
If you are a lessee, you lease it out from me for a particular period of time by way of a lease agreement or deed of lease.
Right.
And if you are a licensee, you do not pay me. I have given you my permission to stay and occupy that particular property. So, you do not pay me anything. But you remain in the property as my licensee. So, disputes arises where these tenants, lessees, licensees are not vacating the premises upon the request of the landlord or the owner. Now, I request you, now Charita, I wish to have my house back. Please give me the vacant possession of my house on no before this day.
Right.
If you do not leave, I have to terminate your licensee in a formal manner. In most of the instances, by writing you a formal letter,
right,
terminating or cancelling my licensee, indicating that I have given leave and license to, for you to stay, but I now decided not to extend that. So, I will terminate it. Please hand me over the property back. So, you have to terminate that. Even after the termination of leave and licensee, the tenancy, lease relationship, still if you continues to occupy, I have to resort to legal remedy to eject you from the premises.
Right.
Now, that is one category of ejectment matters in relation to lands, where a person who is in occupation of the property with leave and license or on a contractual relationship, we call it a contractual relationship. You may be a tenant, you may be a lessee, you may be a licensee, but all in all, we have a contractual relationship.
Right.
So, a person who enters into a property, enters into a land, a house on a contractual relationship, refuses to vacate, then I have to go before court seeking an ejectment order to get you ejected from the land.
Right. So, the small question when it comes to those tenant agreement or something like that, if in your property I am living, I am paying a monthly amount, for example 25,000 to you on a monthly basis, and we have an agreement for a period of 1 year. So, the agreement states that before 3 months you can just inform me and make me move out of the position.
Yes.
In that case, or once after the period ends, you have the right to not to extend or ask me to leave. I'm saying that please give me some time. I have no any other place to live. Although I have legally bound to end the agreement within this stipulated time period, I'm saying that I have nowhere to go. What is the legal remedy that you can see?
Yes, legal remedy is that now, Charita, you and I have been entered into a contract, a contract of lease. So, it is a notarially executed document.
Yes.
Remember that I
Yes.
explained you earlier that no transaction pertaining to an immovable property is valid unless it is a notarially executed document.
Yes.
So, now the lease agreement between you and I is a notarially executed contract.
Right.
So, both parties are governed by the terms of contract and also both parties are bound by the terms of contract. So, that is, before entering into contract, you and I agree upon these terms. So, neither party on its own can walk away or just abandon or to ignore these conditions, because it is pre-arranged, pre-agreed, and then have come into this agreement. So, both parties are abide by this lease agreement. And so, now on like now your example is you have no where else to go. So, therefore, you request me to permit you to remain in possession. So it is purely on my choice.
Right.
So I have the choice to decide that, because we have agreed at the time of entering into the lease agreement that it terminates or it expires on this day, and that I have the liberty, the lessor has the liberty to terminate it before the expiration of the lease agreement. And now in 2023 the Parliament enacted the law, the first law, that is 1 of 2023, and honestly I do not want to use a lot of legal terminology because it might for our viewers, but in 2013 an act was passed by the Parliament, 1 of 2013, with regard to this overholding lessees. Now the problem of this overholding lessees is so much where landlords and the owners of certain property are deprived of their rights to the property because of overholding lessees. Now for example, now say you enter into my property for a period of 1 year. So I enter a lease agreement with you anticipating that you would vacate in 1 year. But if you deliberately fails to vacate the premises, and if you deliberately remain in possession, you will gain undue advantage and I will suffer an undue loss.
Right. Yes.
So, and as I indicated to you earlier, that soon after the expiry of your lease agreement, and if I do not permit you expressly to continue the occupation, your stay is illegal.
Right.
But still I cannot forcibly throw you out.
Right.
So I have to go before court and to institute legal action and to take a court order to eject you. So in order to expedite this process, because you know these overholding lessees, they took the maximum advantage of lost relays in our country. So it's common knowledge that there's a huge backlog and there's a huge delay in our court proceedings. So the overholding lessees took the maximum advantage of that, and they went before court to litigate, and the litigation continued for years.
Right. If it's exceed 10 years, can we claim prescription in that manner?
No, that is a very good question because now the 10-year period that it is calculated in this way.
Right.
As long as you pay rent or lease to me, you do not enjoy any adverse possession.
Right.
Your possession is under my permission.
All right.
Right? Soon after you refuse us to pay me rent or lease, then you start to possess it adversely. So that is against my rights.
Right.
So the 10-year period starts to operate or starts from the day you refuse us to pay me your rent. But if I institute action against you before the expiry of 10 years, you cannot claim prescription. Now what I was telling is, now 1 of 2023 is an act which was introduced by the Parliament to expedite the procedure in relation to overholding lessees. Now, overholding lessees cannot drag these matters further. They have to vacate immediately because it will be tried in a more quicker way.
That means, like the people who owns the particular property, they have to institute an action at the earliest convenience. Otherwise, the time period drags on and exceed the time period. They have nothing to do.
Yes.
Because a certain judge, as far as I could remember, saying that sleeping on the rights, they won't recognize by the courts.
Right. That is called law does not help the invigilant. You have to be vigilant about your rights. So you have to be promptly act upon to safeguard your rights.
Right. So, like when it comes to demarcation of boundaries, there are certain many disputes. Like this tree belongs to me. This is not like previously. This was there. Now with the new new demarcation, now this tree belongs to me. And like with the shift of the soil, now this has come to my side. Many disputes. Yes. Can we expose that?
Yes. Now boundary disputes are very common, Now, especially in rural areas, now in urban areas, your boundaries are fixed, where you have put up parapet walls and concrete and brick
even
walls.
we can't deliberately we can't move.
you can't change your boundary. But in rural areas, yes, there is a huge problem with regard to these boundaries. But now, when it comes to a boundary dispute, you have two options. One is there is a type of action called demarcation of boundaries. Now, in order to institute a demarcation of boundary action, there are two requirements. One is there should have been, or there should be, a permanent boundary existed earlier, and then later it was obliterated. Later it was destroyed, or it was obliterated by your neighbor or someone else. So now there is an uncertainty about the boundary, because there had been a permanent boundary. Later it had been obliterated.
Right.
So in those instances, without resorting to declaration of title action or ejectment action, what you can do is you can simply file an action for demarcation of boundaries. In those actions, you have to admit the title of the other party, your neighbor, and the neighbor has to admit your title. So it's mutually agreed upon. The title is not in dispute.
Right.
So the boundary is only the dispute. So you can easily sort it out by calling, by surveying it based on previously prepared plans.
Right.
And if the other party, if your neighbor has encroached into your land, and he has changed the fence, if he had changed the fence and encroached into your land, now this is what happened. Now let me tell you a small example.
Yes.
Now there is a small jack tree planted at the boundary. After years, this jack tree become bigger, and then your neighbor claims that now the boundary, your earlier boundary, was from the edge of this jack tree.
Right.
So it has to be shifted, because jack tree has grown.
Yes.
Right. So you move the boundary towards your side, because you are claiming that according to the growth of the jack tree or the trees in your boundary, that particular portion belongs to you. So this can happen. Some people may do it with ignorance, but some people might intentionally do that. But you have to first identify whether there is an encroachment or not. If it is merely uncertainty of boundary, you can go before court by way of a definition of boundary case. But if it is an encroachment, that is the other party, your neighbor, has come into your land and has forcibly taken a part of your land annexed a part of your land into his land, then that cannot be solved by way of a simple demarcation of boundaries case. So you have to prove that you are entitled to this portion.
Right. Okay. So at the end, I would like to enlighten a small scenario. If a particular last will is there, according to the last will, there are some specifications mentioned. This property should be allocated like this. So if A is the father and BC are the son or daughter, can one claim that now this is not the last will, I should can one oppose that last will?
Yes, definitely. Now last will, now if you claim your ownership based on a last will, there is a prerequisite that you first must prove it before court. You cannot now, if suppose that I claim a certain property on a last will of my father, right? So I cannot claim that property without proving the last will first. Therefore, if a person dies leaving a last will, in a last will, you know that a person has to be named as a person to carry out the intention of the deceased, according to the will. So we call him is the administrator of the estate. So this last will must be bring into courts and to prove. If you do not prove it, then you cannot claim anything from the last will.
Right, that means last will executed must be proved. Without proving, nothing can be done. Right, so that comes to the end of the common disputes regarding the land. We have discussed more insightful areas in order to give you a thorough understanding about the land law. So thank you very much, ladies and gentlemen, for watching us. We'll be doing a few more episodes on land law. Thank you very much, sir. Mr. Sapamal Bandara, attorney at law, for doing the honors with us on this most important area, the land law. So Law and Order is a program where we approach to all your legal scenarios, cases, and giving you a thorough idea about the law that is governing in the country, and even updates in the law, that you can expose yourself to the latest knowledge and live a successful life without falling in trouble, without knowing the law. So thank you very much for watching. Have a pleasant day, and do watch us the rest of the programs, and stay tuned with Law and Order for more insightful areas.
Feel little uncomfortable